I'm Ben Meiselas from the MeidasTouch Network. The D.C. Circuit Court of Appeals just handed another big loss to Donald Trump. Donald Trump appealed the lower federal court ruling, which would have compelled former Vice President Mike Pence to testify on mostly all of the things that he saw and observed leading to and after the January 6th insurrection. The federal court judge, Jeb Boasberg, carved out a small portion where he ruled in favor of former Vice President Pence's request for limited speech and debate clause immunity. I'll talk about that in a little bit, but generally allowed the Department of Justice to subpoena former Vice President Mike Pence in connection with special counsel Jack Smith's ongoing criminal investigation into Donald Trump's 2020 election interference. And former Vice President Mike Pence said, you know what? I am not appealing this ruling based on the arguments that I made, and I will testify before the grand jury in Washington, D.C., investigating Donald Trump for crimes. However, Donald Trump filed an appeal to the D.C. Circuit Court of Appeals, which just issued a ruling, and Donald Trump filed an appeal on different grounds. And I'll talk about the technicalities here, but let's get to the point right away. And this is the ruling denying Donald Trump's appeal, which Donald Trump tried to block former Vice President Mike Pence from testifying. And grand jury proceedings are under seal, so we don't actually get to see a full ruling, but we do see the docket sheet where the D.C. Circuit Court of Appeals denied Donald Trump's appeal. And the denial was done on a per curiam basis, or a unanimous ruling. So all three judges on the panel, there was one Trump appointee and two Obama appointees, all three agreed to reject Donald Trump's appeal, trying to block Pence from testifying before the grand jury. Here's the order right here. It says sealed, redacted, per curiam order, and per curiam basically means all of the court is in agreement, and it's sealed, meaning it's confidential and it's not, the order is not released publicly. It says the emergency motion is denied before Judges Millett, Witkins, and Katsas. Millett and Witkins, Obama appointees, Katsas, a Trump appointee. But the filed emergency motion, that's the emergency motion filed by Donald Trump, is denied. So what is the result of this? Absolutely, former Vice President Mike Pence will be testifying before the grand jury in Washington, D.C. very soon, before special counsel Jack Smith and Jack Smith's team that is criminally investigating Donald Trump. So I'm sure we will see a post by Donald Trump on his social media platform soon, whining and complaining about this ruling. But let's be clear, a Trump appointee also agreed with the two Obama appointees. This was a unanimous decision that Donald Trump lost. So just to refresh your recollection, when a subpoena was issued to former Vice President Mike Pence, initially both Mike Pence and Donald Trump filed different motions to try to block special counsel Jack Smith from getting testimony from former Vice President Mike Pence. Mike Pence made the argument that under the speech and debate clause in the United States Constitution, because even though he was the vice president, he argued he was serving on January 6th as the president of the Senate in his ceremonial role. The vice president also serves as the president of the Senate. It does the tiebreaker where there's a tiebreaker needed in the Senate, and also has the ceremonial role, for example, of counting the electoral votes on January 6th. So Pence said, I should be entitled to the same immunity that members of the House of Representatives and senators get under what's called the speech and debate clause of the United States Constitution. And that has been interpreted through a variety of cases before the Supreme Court. The most notable one is United States versus Gravel, a case from the 1970s that basically said for all legitimate legislative activities by members of the House of Representatives and senators, as well as their staff, and legitimate legislative activities on the House floor or even outside of the House of Representatives, they have immunity from testifying, and they also have immunity from being sued on those issues. And things that are outside of legitimate legislative activity include things like engaging in criminal conduct or exhorting or extorting or putting undue pressure on people to do things. Also, statements made to the press are outside the scope of legitimate legislative activities. And so Pence said, all of my conduct should be protected under the speech and debate clause. Special counsel Jack Smith said none of your conduct should be under the speech and debate clause. And ultimately, the presiding federal judge there, Judge Jeb Boasberg, basically said, look, Pence, for the small amount of time where you were counting the electoral votes on January 6th, when you were in that ceremonial role as president of the Senate, then you have immunity. You don't have to testify about what took place then. But all of the communications and conduct leading up to the January 6th insurrection that you viewed and observed, that is outside of legitimate legislative activity, and or you're not even covered by the speech or debate clause in the first place. So Pence basically said, well, that's kind of a win for me. It really wasn't, because Pence said, I don't have to testify about these things that took place on January 6th. But the reality is that special counsel Jack Smith's investigation is not really focused on what happened while Pence was counting the electoral votes itself. That was on C-SPAN. That was on TV. We all saw what happened. So special counsel Jack Smith, though, is going to get to the heart of the matter and get all of this knowledge, all of this observation of former Vice President Pence leading up to January 6th and after, about all of the conduct that Donald Trump engaged in. Now, Donald Trump also filed to block the testimony of Pence, but did not make an argument under the speech or debate clause. The argument that Donald Trump made was one of executive privilege, and Donald Trump claimed that as a former president, he can assert this executive privilege so that all of the communications between him and his staffers would be shielded from discovery. That's a faulty argument and, frankly, a frivolous argument for a variety of reasons. The first and foremost is that former presidents really aren't able to assert executive privilege, where the current president, the current executive branch, is not asserting executive privilege, and President Biden is not asserting executive privilege over Donald Trump's conduct on January 6th and Donald Trump's conduct related to a criminal election interference. So there's a small body of case law that says a former president may be able to assert executive privilege in inter-branch disputes, maybe a former president and, let's say, Congress. But this is not an inter-branch dispute. This is the Department of Justice, through special counsel Jack Smith, wanting information about the executive branch. It's executive branch wanting information from a former executive branch where the current executive branch is not asserting executive privilege. Second, even if there was a valid assertion of executive privilege, which there was not, an executive privilege assertion can be overcome. It can be defeated. It's not an absolute immunity. If the Department of Justice shows a compelling need, and clearly getting this information about a coup, about election interference, about attempts to overthrow a free and fair election, would clearly satisfy that standard of a compelling interest. So for both of those reasons, Donald Trump's claim of executive privilege was totally shot down by the federal presiding judge, Jeb Boasberg. So in the federal court, the lower level trial court, the presiding judge, the chief judge who oversees the grand jury proceedings now, it used to be a chief judge by the name of Beryl Howell. You may remember me talking about her. Now it's a chief judge, Jeb Boasberg. Boasberg said, Pence, your claim of speech and debate clause immunity only applies to that small period of time while you were counting the electoral votes, while you had that ceremonial role. Otherwise, you need to testify. But Donald Trump, your argument is completely without merit. I'm rejecting it. Pence never filed an appeal. Pence said, I'm fine to testify, and I accept the judge's ruling. Donald Trump filed the appeal to the D.C. Circuit Court of Appeals, and I just read you the ruling, the sealed, redacted, per curiam order rejecting Donald Trump's requested relief. And if you go back and you watch some of the videos I did, I was 100% confident this would be the outcome by the D.C. Circuit Court of Appeals, because the precedent is overwhelmingly against Donald Trump. Now, who set that precedent? Donald Trump. Donald Trump has consistently been asserting executive executive privilege over everybody in the White House, and he's failed at each level. He's failed before the federal judges, and he's failed before the D.C. Circuit Court of Appeals for the reasons that I just explained to you about the analysis about why executive privilege doesn't apply. So Donald Trump trying to assert executive privilege here when he's lost on that argument like dozens of times with other people who have already testified before special counsel Jack Smith was a losing argument by Donald Trump, frankly, a frivolous one. And now with this ruling by the D.C. Circuit Court of Appeals, former Vice President Mike Pence will be testifying shortly before the grand jury in Washington, D.C. We'll keep you updated when that happens. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. Hit subscribe right now. Also, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. Become a member if you want to help support grow this independent media platform. Don't worry if you can. Also, wherever you get your audio, subscribe to the MeidasTouch podcast on audio. It's free to subscribe to the MeidasTouch podcast on audio. And now, if you can, subscribe to our YouTube channel. It's free. Thank you so much and have a great day.
Love this video? Then you'll love the MeidasTouch podcast. Listen as my brothers and I break down the latest news and chat with top political leaders on the fastest growing pro-democracy podcast in the world. New episodes drop every Tuesday and Friday. Add the MeidasTouch podcast right now wherever you listen to your podcasts.